So if you lived in the Phoenix area during 2005 and 2006, you know that it was one of the scariest times that we've ever experienced. What we're talking about today is the Phoenix serial shooters, Dale Hausner, Samuel Dietman, and their recreational violence that they put on full display to terrorize neighborhoods in Phoenix for over a year. They went to trial, and we're going to break down that trial today. We're going to talk about it in depth, and we're going to analyze and understand better what they did, how they did it, and what happened as a result. So Ryan, this is Ryan McPhee. I'm David Lish. We're both criminal defense lawyers here in the Phoenix area, former prosecutors who've handled many, many cases through the years, and so we're going to break this one down for you. Let's start the autopsy.
Absolutely, yeah, and this is one of those cases that, a lot of these cases that we talk about, we're doing some research on, and we're saying, yeah, I hadn't heard of this case.
Right.
Right. This is the serial shooter case, and it's one that anybody who lived here at the time knows about it. Like, we remember it. It was scary, it was crazy, and one of the craziest things about it is that it happened at the same time as the other pretty much worst serial killer ever to be in Arizona, which is the Baseline Killer, which we've talked about, literally at the exact same time.
Yeah, those two periods overlapped. And so for the serial shooters, we're talking about between May 2005 and August of 2006. And kind of an overview of what was happening was police started to notice some kind of strange shootings and eventually homicides that were recurring almost at random. There was very few things about each of these that were similar, except that some of them did fit a certain pattern. It started with the killing of animals, some dogs, a horse, and then people started getting killed. And they spanned kind of all over in different areas.
Yeah, there was really some odd things about it, too, is that they noticed there were different weapons or different calibers of bullets that were being used. But they did kind of hone in on, I think it was about two.
So 22 caliber rifle.
410 shotgun.
And a 410 shotgun.
I think they said there was a 12 gauge on another one, but I could be wrong. Maybe that was a different source that we saw. So they were able to kind of catch some of those patterns, but I think, not to get too far ahead of the story, I think this is a story where this was a complicated situation where obviously on the back end, we now know that there were these two serial killers at the same time. Think about it on the front end when you're trying to do the investigation and all you have is these deaths or these injuries that are happening, because many of these people that were just, like you said, randomly shot on the side of the road survived. So while there were multiple murders and multiple deaths, there were also just a ton of injuries of people that didn't die from it. Simultaneously and in similar areas, we had rapes and murders going on that turned out to be somebody else, right? And they had to kind of parse out these two sets of serial murders and other crimes going on, and it was a task force. They basically had to put out two big task force once they were able to kind of identify that there were two, and it was complicated.
Yeah, and not only that, but at the beginning, police didn't recognize that this was the same person committing these crimes. I mean, homicides happen all of the time. Phoenix is a big city. Phoenix is actually several large cities all clumped into one, and you have different law enforcement agencies all over the valleys, what we call it. And those law enforcement agencies don't always know what the other one is up to. Somebody may be investigating a murder over here and somebody else a murder over there. How do you know that those two things are linked? And it took a while before those lines were drawn between them, and then complicated with the idea that the Baseline Killer, who's also committing different but similar homicides and sexual assaults, kidnappings, how do you separate them? Thankfully, police were able to, figure out what was going on, but it really happened because of a random incident, okay? So these two guys who were eventually charged, Dale Hausner, who I'm going to say is really the leader of the two, and his friend Sam Dietman. Well, Sam Dietman, after a bunch of these crimes had been committed, people had been killed, animals and others had been shot, Sam runs his mouth. He was at a bar. He had some alcohol to drink, and he's talking to a buddy, Ron Horton, I think is the guy's name. He mentions to Horton, hey, I'm involved in these.
Or you ever killed anybody?
Yeah.
I think that's how he said
So
it. Started it out.
he runs his mouth. Horton doesn't initially come forward. I don't know if he thought that maybe, Dietman was just talking, but then another murder happens, and then Horton ends up going to the police. And what's interesting after that is police then begin to put eyes on Dietman, okay?
Yeah, it's really an interesting way that they did this, in going through it. And you think about there's basically been this double task force manhunt for over a year, right? With almost no information, very little to go on at that point. The other interesting thing that we've seen on stuff like this is there were tons of leads coming in.
Sure.
A lot of calls because the public had called, or the police and the mayor and the governor had called out for people to say, please help us, solve these crimes. So there were tons of tips coming in. And what we see on some of those super high profile cases is things get missed, right? Like a call comes in and you find out that somebody had called in on something 4 months ago. But again, to the police credit on this one, they quickly acted on it and it all kind of unraveled quickly for these guys.
Yeah, and so police, they then had information about Dietman, but they were unaware of Hausner. They didn't know who he was or whether he was involved. Turns out that in following Dietman, they see that Hausner now is involved with him.
Yeah, so they did kind of a clever thing, right?
Yeah.
Where they said, hey, Horton, go ahead and set up, a drinking appointment. Get together with Dietman. But tell him that you can't drive him home, so he needs somebody to drop him off. So they obviously had some indication that this was a two-man crime that was happening, one person driving, one person shooting.
Right.
And so, sure enough, they had recently gotten a description of a vehicle. That vehicle, an old Camry, showed up, dropped off Dietman at the bar, and they see Hausner. And like you said, this is the first time they have the name. They're able to trace that plate to the name of Dale Hausner.
Yeah, and then so they follow that car. They see that Hausner drives with Dietman, he meets Dietman at a casino, and then they see them open the trunk. They remove a duffel bag, put it in the back seat. They leave the casino. And this is interesting. Over the next 2 hours, police followed them as they drove through several cities in the southeastern Phoenix metropolitan area. They appeared to drive aimlessly through business and residential neighborhoods, but when they approached pedestrians or bicyclists, they slowed down and sometimes circled back to pass the persons again. At about 4 a.m., they returned to Hausner's apartment where an officer overheard one of them say, quote, "It's probably because of the rain," as they walked inside. Can you imagine how scary that might have been for police? You're now following the car that you believe may be driven by the serial shooters. And for 2 hours, you're following them around as they're driving aimlessly in the valley. You don't know if they're going to commit a crime in front of you.
They're obviously
they're trolling for victims.
displaying
Yes.
the kind of behavior that you would expect. And, going through it, once they found these guys, like once they had them at the bar,
Right.
They weren't out of sight for 3 days until this, arrest was made.
Correct, except that police didn't have enough information either to search their home
Or arrest
to
them.
arrest them.
Yeah.
They were really just going off of suspicion that these guys might be involved. And so I think it's important. Let me continue to read some of these facts because knowing these facts helps to understand why the court did what it did, because Hausner later challenged this.
It becomes an interesting issue.
Okay, so
Yeah.
it says, on the evening of August 2nd, detectives met with Maricopa County attorney, who at that time was Andrew Thomas, who's since been disbarred, by the way. Andrew Thomas, who approved an emergency wiretap for Dietman's phone and for Hausner's apartment and car. What's a wiretap? A wiretap is not a search warrant. It's not allowing you to go in and search after the fact. It is monitoring things real time. So when we say wiretap, that's a bug in his apartment. That's a listening device.
And that's tricky.
And it takes extrajudicial authority in order to get a live wiretap. Under this circumstance, the county attorney, the police, in conjunction with the county attorney, did what they call an emergency wiretap, meaning they didn't go to a judge. They invoked a particular statute. In fact, it's ARS 1330-15 that says under emergency situations, the county attorney himself can go and can authorize the wiretap on sufficient information from the police, and later, within 48 hours, go and get judicial approval of that wiretap. But because of the need to do it right away, you can skip a judge for a moment and then later ask for permission. And so they did that.
Yeah, and there's two big important pieces I'm sure we'll talk about with that, right? Is number one, you're balancing somebody's right to privacy.
Absolutely.
Because this is a huge violation, you could say, of
invasion
of somebody's privacy. And you don't just want some elected official to be able to just do that anytime. And so there are safeguards in place, and we'll talk about that on making sure that all the T's were crossed and things were done correctly, because you could see the danger in that if we just allowed people and elected officials to just wiretap.
That's right. And so there has to be that balancing. But in this circumstance, gosh, you've got, guys that are terrorizing the valley, and police saw at least some of it, right? They didn't, or at least the suspicion that it may be going on.
And you think about, too, I mean, there was just so many, right? Like, they were doing this so often and with so many victims that it's not like this had happened 4 times, right, over a year period. Like, anyways, you could see that what they were saying, why it was an emergency at that time.
That same night, detectives also obtained warrants from a judge authorizing police to place wiretaps in the car and the apartment. From about 9:35 a.m. until midnight on August 3rd, the police monitored conversations in the apartment. Hausner and Dietman made several statements implicating themselves in the shootings, including comments boasting or joking about certain killings and mocking their victims. Police also collected items from a bag Dietman put in the apartment dumpster that included a map of the Phoenix area with markings near some of the shootings. Hausner's and Dietman's fingerprints were on the map. The discarded items also included .410 shotgun shells, a written note listing Robin Blazek's name. Robin Blazek was the last woman to be killed, 22-year-old girl in Mesa.
In Mesa, yeah.
And I almost hate to mention this, but one of the things that the police heard on this wiretap of Dietman and Hausner, it says mocking the victims. They called Blaznek Blastnek for shooting her in the neck. I mean, awful, awful, awful. And so we ask the question, was that wiretap needed? Was it important? Absolutely. Who else is going to talk like that except the people who were involved? They found newspaper articles and clippings related to the shootings. Near midnight on August 3rd, police arrested Hausner and Dietman. Hausner admitted owning a shotgun, but told detectives he was not involved in the shootings. He also mentioned that a .410 shotgun had been used in the shooting, which was interesting because police never let that out to the public. So Hausner knowing that a .410 was used was a critical fact that really nobody else knew.
How is it that you're here then, sir?
Why I'm here is because I have Sam Dietman staying with me for about 5 weeks. And apparently at night, Sam had been taking my car out and using various weapons that I have in my house to commit crimes.
Dale's press conference really confirmed with me the psychopathic nature of his personality. He was a master manipulator and a masterful liar.
Are you a serial shooter?
Absolutely not.
And then on August 7th, Hausner holds a press conference and says that he denies. They search the apartment. Yeah. They search the apartment. They find guns, ammunition, news clippings about the shootings, 22 shell casings, .410 shot, and I misspoke, a 20-gauge shotgun shells. You were correct. Hausner had once owned 2 22 caliber rifles made by the Marlin Company, and Marlin pattern of tool markings were on the 22 shell casing. So a treasure trove, we'll say, of evidence inside that apartment. And so now this case comes together. These 2 guys have been arrested. I believe Phil Gordon was the mayor of Phoenix at the time, and I remember his press conference, which if I were a defense attorney defending these guys, I would take an issue with. He says, to the public, we got him, okay?
Which looks forward. Do you remember the other situation where Doug Ducey did the same thing, and it turned out we didn't get him?
Oh, that was the freeway shooter.
The freeway shooter
They had
is
to
the
let that
wrong
guy
suspect. And after Ducey's like, we got him.
Well, turns out you don't got him.
Yeah.
Anyway, so these guys are now in custody. The county attorney's office goes to a grand jury, And, for a number of reasons, I don't know all the actual, reasons behind it, but they get 5 indictments. I don't know why you wouldn't do a single grand jury presentation, except that sometimes things get a little bit disjointed. So they got 5 indictments, a total of 88 charges. Go ahead.
Let's clarify what that means, right? Is so an indictment is a set of charges or counts, right? So you can say, what was it, 88?
88.
Yeah, so I mean, over that number of things, like with the baseline killer, they kind of broke it up into the rape cases versus the murder cases. So maybe that's how they did it. They were doing it, the animal killings versus I don't know.
Right, but one of the issues that was raised in the appeal was joinder. So they get 5 indictments. They join them, even though they're separate batches of charges, they join them for a single trial. Hausner only went to trial once.
Right.
And so baseline went to trial twice.
Right. Those were totally separate. Yeah.
And one of the issues that Hausner raised was the idea that these were improperly joined. You can't group all of those indictments together. And the court resolves that by saying, well, they're part of a common scheme or plan. And that's technical language that comes from the rules of evidence, but it's also very understandable language for just about everyone to understand. You say, look, these are part of a common plan. Well, yeah, these guys were rolling around shooting people. It was all part of what they did. And that's how the court analyzed it because of the similarities and such. And so they're able to group all those together. There's a single indictment. The jury hears the entire case, the batches of cases as a single case.
And we've talked about this before.
Sure.
From a defense perspective, it's obvious why you wouldn't want that, right?
100%.
I mean, especially, we haven't even talked about that they set 2 Walmarts on fire, right? Like, these guys were prolific. They were doing a lot of stuff, terrorizing, like you said, the community. And obviously, if you could see how they would make the argument that that's totally unrelated, totally separate. Right?
Yeah, if I want to go and burn down a Walmart, we can have a trial without burning down
because
Walmart.
The truth
if I'm going to
is,
shoot a horse, let's talk about the horse.
Because the truth is, jurors who are deciding guilt and innocence are human beings, and if they hear about that, at the same time they're trying to make a decision on whether there's enough evidence to convict you of something else, it starts to mount, and sometimes those things bleed into themselves, and they find you guilty of one because there's just so much. There's so many things.
I agree with you 100%, except in this case, when they went to trial, there were 88 counts that were charged. Jury convicted on 80 of 88 counts. So, to me, that's a signal that the jury they considered this. They didn't just say, guilty on everything. They probably considered count by count as they're supposed to.
That's an interesting point. Yeah, I mean, especially when there's that many. I mean, how long would it have taken just to come up with the jury forms, right? Just to come up with the verdict forms.
At the outset of the program, you mentioned, living in the Valley at the time. You and I both lived here. I was a prosecutor at the county attorney's office at the time. I mean, this was like peak county attorney time for me. This was right in the middle of my career there. I would go on my kind of off time during the day, if I had a minute, I'd go and watch part of this trial.
Yeah, we talked about this. I was there too. We might have been sitting in the courtroom. We didn't know each other at the time.
It's entirely possible. You and
I think I was in law school.
Yeah.
At the time, and I was just like, this is fascinating. And I just was a nerd who'd go in and watch some of the trial.
Well,
I saw Dietman testify.
Yeah, Judge Roland Steinley presided over the case. The prosecutors were Vince Imbordino and Laura Reckert. I can't recall who defense counsel was. But yeah, I would pop in, watch some trial. Sounds like you did the same thing. One of the big moments was when Andrew Thomas, in an evidentiary hearing, had to testify about granting that wiretap.
The elected county attorney. Like, that is highly unusual.
How often does that happen? It never happens.
Yeah.
And that's rarely a provision that gets invoked. It's just so few and far between that we have those types of emergencies.
So to be clear, he didn't do it, and you pointed this out to me when we were talking about it, not in front of a jury or anything like that.
Right.
This is an evidentiary hearing where the defense says, this piece of evidence shouldn't come in because of X, Y, and Z. It's exactly what we're talking about with the wiretap. So in order to establish the purpose and the justification for it, the actual county attorney who approved it had to come in and testify.
Yeah, it was fascinating. Yeah. And anyway, so that trial was, and it went on for months and months and months, not the evidentiary hearing, but the trial, because there was so much evidence. Now, a couple of things to clarify. Hausner went on trial alone. Dietman pled guilty, and he pled guilty under an arrangement where he had to testify against Hausner, and the prosecutor structured the plea deal such that he could either get life or death.
Really unusual.
As a result.
Really unusual.
Now, think about that for a second. Why might the prosecutor leave death on the table? My opinion is because in cross-examination by the defense, the jury has to believe Dietman. He's your star witness. And if the defense can say, well, you're only testifying against my client because you got spared the death penalty. You got a deal. That's why you're here testifying. And if that deal, however, is structured such that death is still a possibility, that completely guts that argument from the defense and says, you're only testifying because you got a deal? No, sir. I still may face the death penalty as a result of this testimony.
Right.
That's brilliance on the part of the prosecutor, in my mind.
Yeah, and from the defense perspective, you're like, why would you take that plea? If it still leaves it on the table, why not go to trial? The practical answer to that probably is that when Dietman did go to sentencing, prosecutor was like, no, he did a really great job for us. In the other trial, he was vital to the conviction of Hausner. Maybe the prosecutor puts in their 2 cents for him not to get the death penalty. I don't know if that's what happened, but
I don't know either. I can't remember specifically, and I didn't spend time studying that point of it. However, I do know that Dietman did get spared the death penalty. He's doing a natural life in prison. And in fact, I just checked on him. I looked him up on the ABC website, and he's still there.
You didn't go pop by and say hi?
He didn't. I guess we should say Dale Hausner, though, was sentenced to death.
You could not see how he's doing.
Yeah, at least not currently.
No.
He committed suicide in 2013, I want to say. Swallowed some pills, and so what he had done is accumulated some narcotics by not taking them, and then he took them all at once and killed himself. Okay, so back to the trial. Okay, so Hausner is on trial. Dietman has agreed to testify. A couple of the things that happened. So number one, Hausner, as we said, gets convicted, 80 of 88 counts. He does get sentenced to death on 6 murders. And on appeal, so his appeal is an automatic appeal that goes up to the Arizona Supreme Court because the death sentence was imposed. And so Hausner then complains of a number of issues on appeal that we're going to continue to analyze. One of these is the dismissal of prospective jurors. We'll start there. Can you imagine the jury pool that was necessary to fairly seat the requisite number of jurors plus enough alternates, okay?
Yeah, just kind of a little bit of insight on that is that the judge says, how many should we get, right? Because sometimes when you're doing a misdemeanor DUI, you can get away with
6.
20 to come in and, you get your jury, but these type of things, a lot more people are going to get weeded out.
Hundreds. Yeah. And I'm sure there were layers upon layers of questions that they had to answer to screen. And then eventually you get to the point where people actually come into the courtroom and you've got to do individual voir dire of the panel. Of course, one of the issues that's raised in a capital case is whether someone has objections to or the ability to follow the law as it relates to the death penalty. A couple of jurors, at least that are mentioned in the opinion, voiced those objections. And Hausner says, well, the court erred in striking those jurors. And not to get bogged down in the details, but jury selection sometimes can be a little bit of a misnomer. It really is not jury selection. We're not picking out the people that we like.
That one. Yeah.
Right. It's bring the group in, figure out who can't be fair and impartial, remove them for cause. And what it used to be is each side used to get peremptory strikes, removals that we could just take based on something that they said or something that we didn't like, as long as it wasn't related to race, gender, religion, or any of those protected classes. Now, those peremptory strikes are done away with. A few years ago, that's gone in Arizona. But here, the jurors are batched in. You can do your strikes for cause. You then do your peremptory strikes. And then you're left with a batch of jurors that becomes the jury. Here, Hausner said, well, you shouldn't have struck those jurors. The court looks at it and says, well, number one, the court was right in removing a juror who clearly couldn't be fair or impartial as it relates to not imposing the death penalty, okay? And then beyond that, they were above the line. And what that means is they already had enough jurors who could sit and would sit on the case, and the ones that were removed were above that number, and so it's harmless.
So the jurors are numbered,
Yeah.
right? So they're already 1 through whatever it is, right? 40. And whatever's remaining, they just take 1 through, right, 12 or 14, right? And so however many it takes to get to that number. So if you, like you said, above that line, even if you made it through everything, if you were number 140, you weren't going to make it in.
You're never going to sit.
And they were saying they were already above this line, so even if, first of all, they're saying there was nothing wrong with the judge removing this person, but even if they hadn't, they wouldn't have been in the jury. So it made no difference.
Yeah, and so that element is resolved in the opinion by saying, the judge didn't do anything wrong.
Yeah, and kind of, sorry, we're done with that issue.
I think so.
The other thing that was kind of part of the trial that it might be later on in this, so maybe smart to jump ahead to it, is Hausner did a weird thing at sentencing, right? So we've talked about this before, but in a death penalty case, there's, really all cases, there's a penalty phase that happens afterwards, after the guilt and innocence phase. So once they say, yes, you're guilty of these offenses, now there's a aggravation phase where they talk about mitigation, so all the good things and why they shouldn't give you the death penalty or should give you less than they could, or why they should give you, the death penalty. And that's an extensive process in capital cases, right, where death penalty is on the line. That there's experts get called about his background, about his mental health, about different things, right? He said, no, I don't want to put on any mitigation. I deserve the death penalty. Judge, please give me the death penalty. I think that the family would be better served, that everything, it's kind of, you don't see this, right, very much. At the same time, he never said, I'm responsible for this, and I'm really sorry I did it, but it was an odd elocution that he did in front of the jury that was about a half hour long. But he said, attorney, don't put on any mitigation for me. I don't want any mitigation because I should get the death penalty, which of course, eventually, and we can talk about that later, what the judge did to make sure that that was fair and everything. Yeah. But that was an interesting thing that he did at the end of the trial.
Yeah, so during the aggravation phase, the state puts on evidence. Well, they rely on much of what the jury already heard at trial. So once the verdict is returned as guilty, everybody sort of steps into this new phase. Part of what the prosecutor did here was say, hey, remember everything that you just heard at trial. Here are the aggravating factors that we want you to specifically find, and they have to find them as proven or not proven. One of those was that a couple of the murders were especially cruel, heinous, or depraved, which is a statutory aggravator. If somebody is killed in a particularly gruesome or difficult manner, that factor may apply. And then the other murders were alleged to have been done in a cold or calculated manner. Again, another statutory aggravating factor that the jury found. And then so what you're saying is, rather than Hausner presenting favorable evidence on his behalf, rather than saying, hey, I should be spared, his lawyers he told his lawyers, we're not doing any of that. Instead, he makes a statement to the jury, and really that's it.
And then later comes back and says,
yeah, whoops, I shouldn't have done that.
You should overturn my death penalty because my lawyer shouldn't have listened to me, and we should have done a mitigation phase. And so then we talk about what the judge did, which I thought was very smart to make sure that was protected, right?
Yeah, and so what they did was the trial court immediately stopped the proceedings, had Hausner examined for competency to know whether or not he was making a rational choice, an understanding choice about waiving mitigation. Because it's a little jarring if in the middle of a capital case, the defendant who's facing the death penalty says, I'm good. I don't need to tell anybody anything good about me. Screw it.
Give me the death penalty.
Give me a death penalty.
And I guess,
right?
He hadn't, this is not this judge's first go around. You say it's Steinley?
It's Roland Steinley.
Yeah.
And in fact, here's what the Court of Appeals or the Supreme Court says. We commend the approach adopted by the trial court and in our supervisory capacity direct that similar procedures be prospectively applied when a capital defendant elects to waive presentation of all mitigation. Because you're giving Steinle a gold star.
Yeah, I mean, Steinle saw this coming, I think, right?
Yeah.
Where he's like, okay, right? You don't want to present any mitigation. What's going to happen when appeals come around? Guess what you're going to say?
Yeah, nobody wants to try this case again.
You're going to say, you shouldn't have done that. And so made him go through competency where they actually evaluated him. So how do you then later come back and say, I wasn't in my right mind? Or, whatever. They covered all the bases to make sure that didn't happen. And the Supreme Court agreed that it was handled so well that all cases, all judges should
We
do the
now
same
direct
thing.
all judges to do the same thing.
Good idea, Stein.
That's right. Not only is it not a bad idea, it's a great idea.
We should do that from now on. Yeah.
Okay, so then let's jump back to that wiretap. That was a real big deal. So
Interesting
you
issue.
touched on this, and I want to elaborate a little bit further. The invasion of someone's privacy, not only into their home to search, but to actively follow them, listen to their conversations, bug their home. That is an incredible invasion by the government into someone's life. It should only be allowed under the rarest of circumstances.
And supervision.
And supervision.
And
all of those
safeguards.
things.
Yeah.
And so what Andrew Thomas did was invoke 133015, which says that a county attorney or an attorney general, in cases of extreme emergency, if using a wiretap can help the investigation or will help the investigation, the county attorney can then authorize police to do that wiretap, and then can, within 48 hours, get judicial approval. Beyond the legal aspects of it, it's shocking to me, and maybe I'm just showing my own ignorance, but it's shocking to me that police can say, may we wiretap? County attorney says, yes, go ahead and wiretap. And then they all of a sudden know how to wiretap? I mean, what are they doing? They're just like, okay, turn the switch on, let's listen. I mean, is it that easy? I don't know how it's done.
My understanding
that blows
on
me
this,
away.
and I just pulled this together from a couple of things, is they made it clear that wiretaps, a lot of times we picture that as your telephone.
Yeah.
Right? It's not. Like you said, it's really any kind of real-time
Listening.
And so my understanding is that they got into the apartment next door, placed a device on the wall, and were able to listen to what was going on in the room next door. I don't know that that's 100% accurate or if that was the only source of doing it, but it is interesting because some people, again, sometimes we have this mentality where like, guy was a murderer. Like, who cares? Right? Like, listen to his conversation. But we always have to come back to that the state, the government, is also balancing that we don't want to live in a society where anytime somebody says, hey, my buddy did this, or some guy just, whatever, you don't have any information, we can now fully just put ourselves into your life.
It becomes
as a
like,
citizen.
remember that old movie Minority Report?
Yes,
right?
I
Future
love,
crime.
I talk about that movie a
It
lot.
really is a fantastic example of how the government, if given the means, can really reach into your life. And so we have to stop that. You and I agree that we have to limit the scope of that. In any event, Hausner, after the fact, says, and he has, through his lawyers, files ahead of trial a motion to suppress, saying, court, you can't allow the evidence that was obtained through this emergency wiretap to come in. It was obtained in violation of my rights. He complains that the county attorney and the police didn't have sufficient information. This wasn't an emergency enough situation to justify it. And the Supreme Court swiftly disagrees with that. They say, no, this was a clear, ongoing state of emergency in the Valley, and they, to their credit, followed all of the technical procedures that they needed to follow, and so that evidence comes in.
Yeah, and if they hadn't, it wouldn't have. Right? Like, I mean, we've talked about this before. We just had that other case where they moved a stereo to look at the serial number, right?
Yeah.
Where if they overstep, if they do the wrong thing, evidence gets suppressed, right? And so we say, meaning it doesn't come in to trial. And so let's say they said, oh, county attorney gave us the search warrant or the wiretap. We get in, we get the emergency wiretap, and then we don't take the next step to bring it to a judge within 48 hours and get it approved. I believe if that had happened, it wouldn't have come in.
Right. And little trivia, I tried my very first trial in front of Roland Steinley. Maybe I mentioned that before. I have every belief that if the county attorney had screwed this up or if police had screwed this up, he would have suppressed this evidence. Now, what does that mean? This was critical evidence. I mean, it got them to Hausner. It got them inside the apartment where they have this treasure trove of information. All of those things, as fruit of the poisonous tree, get excluded. Could you have tried these fellows for murder? No, I don't think so.
So let's point. What do you mean by that? For those that don't know what fruit of the poisonous tree is.
So basically, if you have a violation, let's say that the wiretap was a violation of their rights and it wasn't done in the right way. Well, clearly, whatever they said on the recordings is precluded. But if those statements, and I'm sure those statements were used later in affidavits
got them
for
the
search warrants to get inside the apartment, then that fruit of the wiretap taints the search warrant that was used to get inside their home, which means not only do you exclude the statements made under the wiretap, but also everything that you find in the home. Police would have been left with very, very little to go on.
Case likely would have been done. Maybe they would have convicted them on something smaller.
Can you imagine that?
Yeah.
That these guys would have been out roaming free saying, hey, not enough evidence, peace out.
Yeah, and again,
we'd get in your Toyota Corolla, let's go shoot him.
And that's what we've talked about before too, right? Is that it doesn't, us complaining sometimes about the state overstepping or doing things in the incorrect way, and so that those things should get suppressed, doesn't mean that we think they should be all the time. It means that if the police and the prosecution and everybody just does everything the correct way that protects everybody's rights, then those things should come in, and they do.
Correct. But I want to dig deeper on this. I think this is a fascinating issue for people to understand. So, as I think about this and as I evaluate this case, I have to ask myself, because I'm a defense attorney, you're a defense attorney. We, over the years and on a regular basis, make the same challenges that Hausner's lawyer made to this court. My question to you and to myself is, suppose you had discovered as a defense attorney that they had made a huge screw up and you represent Hausner. Number one, would you still make that challenge morally as Ryan McPhee? Would I? And two, could you live with the result?
And my answer to that, sometimes people have a hard time with that.
Yeah.
And my answer is 100%. I would make that argument and I would sleep just fine at night. Not because I like
Mesa, though. You're gonna move.
No, yeah, I would move. They usually don't shoot around home, but they did, I guess. Yeah. So the point is, right, if we are willing to violate anybody's rights because we already know they're guilty, if we are willing to just skip those steps, then we live in a society where anybody could be convicted of anything at any time if they cross the wrong powerful person. And then we have to hold these rules into place. Again, it doesn't mean that they can't find the bad guy, right? Or convict people that do bad things. It means they have to do it in a way that doesn't violate their rights, and they certainly can do that.
And I think if those rights mean anything, they have to apply in tough situations like this.
To everybody.
To everybody. And I can think of, and I'm sure you can too, I could tell you a dozen cases that I've handled right off the top of my head where my client was set free, my case or evidence was suppressed, or other good things happened on behalf of my client that caused the state to have to dump their case. And, am I okay with it? Absolutely, I'm okay with it. Now, would it be a little bit of a gut punch in a case as magnificent as this one? Of course it would be. You wouldn't be human if you didn't feel those things. But at the same time, I 100% believe that if there was a violation, that evidence ought to be suppressed.
And sometimes people say, oh, you got that dismissed on a technicality, right? And I always just say, I don't consider the Constitution a technicality.
Fantastic response. I agree with that. Yeah. Anyway, so something that I think all of us should ponder on a little bit, right? It's worth digging down and understanding, how do I feel about that? Anyway, so it's something that I think is very important. Another issue, we've already addressed joinder. The court says that those indictments can remain together. There was an interesting issue about what they call sufficiency of the evidence. So a judge in the middle of a trial screens the evidence, or has the duty to screen the evidence before it goes to a jury to decide, is there even enough evidence to go to a jury? And one of the issues that Hausner raised was whether these killings of animals was sufficient. Was there enough evidence to show that that he committed those murders? As to all of the dogs, the court found a number of circumstantial pieces of evidence, the ballistics, the timing, the locations, and other things, to say, there was sufficient evidence to go to the jury. However, as to the horse, this horse named Apache, the court actually dismissed that count on appeal, saying there really wasn't a whole lot of evidence to show that Hausner shot the horse.
Which is fascinating, right? Because the jury found him guilty of it, right? Like, isn't that the jury's job to say that's like, how did they, especially in light of what you said, which is they seem to have really considered each count and done that. But, we've talked about this. I think sometimes, I don't know, if this were the only count that he was found guilty on, would the Supreme Court have overturned this one? I don't know.
Yeah, I mean, did they throw him a bone here?
Right.
Maybe. But, to be fair, the evidence that he shot the horse was fairly thin. It was a horse, shot by a .22 caliber bullet. But really, they couldn't exactly pin down precisely when it happened. It was nearby one of the shootings of a dog, but it just wasn't enough. And so I think the court says, hey, Hausner, we'll do you solid. There wasn't enough evidence on the horse. Not that that makes any difference on his sentence.
Zero difference.
None.
Right.
Yeah.
But maybe for the owner of Apache, that was a big piece of
frustrating,
injustice.
Right? Can you still get restitution for the horse on that count? I don't know.
Good question. I don't think anybody got any restitution out of that Hausner guy.
Yeah, I don't think he had anything. Plus, he died a few years later. Okay, a couple of final things, and then we can wrap it up. Hausner complained of a number of pieces of evidence coming in against him in the trial. For instance, there was an inconsistent statement offered by a witness. I don't think that necessitates much discussion, other than if a person says something, if a person says the light is green on occasion one, and then at trial they say, well, no, the light was red, they can be impeached with the prior statement of the light is green, right? I mean, not everybody knows that. I'm teaching you that. Prior inconsistent statements can come in.
Absolutely.
Yeah. Another issue
and I guess the difference for that is I guess it's not really hearsay because they're testifying anyway.
But the previous statement is the hearsay
it's
statement.
exception to hearsay.
Yeah, and then he complains that evidence that he was bisexual, that he had set fire to a tree, shoplifted, was present when his brother Jeff Hausner stabbed a man, made obscene gestures to victims' parents in the courtroom.
Hausner actually did that during trial of victims'
let's
parents.
Talk about that one for a second. So Hausner testified in his own defense.
Because he thinks he thought he was a great orator, I think.
And oftentimes that happens, right? Yeah. People who may have sociopathic or narcissistic traits sometimes think that, if I can just get in front of a jury, well, then I can talk my way out of this whole situation. I can't speak for Hausner if that's how he was. I suspect that was likely the case. But yeah, during the proceedings, maybe during a break or something, somebody saw him flip off the parents of Estrada, who was one of the homicide victims.
Like the first homicide.
Gave him the middle finger. And then when Hausner testifies, he talked about how tragic this whole thing was, and how, he feels sad for, the victims. And then the prosecutor cross-examines him, saying, well, do you feel so sad that you would have given them the bird during trial? Is that how sad you feel?
And he was saying that was improper.
Well, you can't be allowed to do that.
Right.
Well, you got to behave yourself. And you have to be careful about what you say. All of these issues that Hausner raised, he opened the door to. And maybe we should talk a little bit about that. What does that mean?
So his argument is to say, well, you can't talk about, for example, the flipping off situation, right? You can't bring that up. But the only reason it was able to be brought up is, like you said, he opened the door by, one, testifying, which he has every right to do.
Sure.
But once you do it, it opens the door to many arguments, especially ones that you create the situation for. So because he had flipped somebody off, and he's there testifying, and he's saying he feels so bad, that begs the question, right? That opened the door to say, well, that's weird, right? Like a person who feels really bad about this tragedy normally wouldn't flip off the parents of a murdered kid.
Right.
Right.
To impeach him saying, well, you don't really feel that bad.
Right.
You did this thing.
So he could, where normally if he hadn't have testified, or maybe even if he hadn't have brought up that this was such a tragedy, right? Maybe that would have been out of bounds to
Yeah,
bring
because
that up.
does it open the door if you're asked, Mr. Hausner, did you shoot Estrada?
Yeah.
No, I did not.
Yeah.
Okay. Did you flip off his parents? No, that doesn't open the door, right? But when you say, gosh, I feel so badly, those such kind parents, such good people, and you give them the bird,
that act is
that
relevant to
doesn't make
what
any
you
sense.
just said.
Right.
Right.
It's, that opening the door concept is one where, let's say in a case of a crime of violence where the defendant were to testify and say, gosh, I would never do anything violent ever. I'm such a peaceful person. And then come to find out they've got a conviction for strangling their wife or something like that. You're certainly going to impeach them with that inconsistent thing, which may not come in, one, if they don't testify, and two, if they don't make the statement, I'm such a peaceful person.
Now
right?
it's
Now
your
you've
job to
opened that
refute
door.
it.
Right.
Yeah.
Exactly.
That's the other side.
All right, so,
And this all
go
came
ahead.
in, too, under what we call our old friend, right? 404B.
Yeah, other acts
We've talked about
evidence.
other acts evidence where sometimes that kind of stuff is not admissible because you're not, the idea is you're not allowed to basically say, this guy's guilty of this crime because he did this other thing, right? So you should take that as an indicator that he's the type of guy who would commit this offense too, right? But under circumstances, we talked about this before, under the rule is 404B, there is other act evidence that can come in for other purposes,
That's right.
and that's what kind of all these were part
Yeah,
of. Right?
so at the end of the day here, again, Hausner gets convicted, 80 of 88 counts.
And there were a lot more murders that he's suspected
two
of.
specifically. So
Yeah.
he gets convicted and sentenced to death on 6. There were 2 additional murders that really are attributable to the serial shooters.
Well, they suspect him, my understanding, of maybe
Think
another
even
10.
more? Oh my gosh,
Yeah,
I didn't know that.
yeah.
Yeah, I mean, again, going back to the time period, what a crazy time it was. And I also think that the way this whole thing played out, it's like it's this big buildup, right? Big catch of this guy, big trial. At the penalty phase, though, it kind of fizzles out because it's like, yeah, whatever.
Yeah.
And then within a few years of him being sentenced,
He kills himself.
he kills himself.
And the other fascinating thing, like you said, this buildup, right, was like people were terrified around the valley. People stopped going for runs. People weren't out walking. People tried not to ride the bus. He shot multiple people at bus stops. And he gets arrested. A month later, Godot gets arrested as the baseline killer. Like, it was a big relief that happened very quickly after, a very long buildup. And then those trials were big spectacles, right?
Big deal. And, thankfully, it's over. We haven't had any sort of copycat or other people like it. But wild times, 2005, 2006. And then, tragic end, lots of people get hurt and killed. He dies. Dietman is now sitting for the rest of his life in prison. And really, this case stands, I think, as a really a landmark of that time period. Both this one and Godot, I think they're forever sort of burned into everyone's memories.
Yeah, and maybe as kind of a juxtaposition to some of the other cases we've talked about, also, even though we are on the defense side, to say this is kind of an example where the police did it right in a lot of ways. I think the prosecution handled themselves well. And the prosecution was done well.
Because how easy would it be to get carried away on this case?
Try to be the famous prosecutor on it.
I mean, contrast, it's a great point. Contrast the behavior of the prosecutors here with the behavior of the prosecutor in Arias. Arias killed one person, right? And Hausner and Dietman killed many. And yet these prosecutors were able to remain composed and follow the law and do it right. And, it shows you that, the law can be enforced in the right way without the antics and the
misconduct.
The misconduct, just the nonsense that paraded throughout that entire trial. Great point. Great point. All right, another good episode. Thank you so much, Ryan.
Appreciate it, Dave.
it.
Yeah.